So, our topic today, main approaches to law. You can see the name of this topic at our first pick. Yeah. Question. Our questions for today. First question will be about legal naturalism. Legal naturalism. I should say that this topic is not so easy. And that is why I'll decide to explain this topic. Then, next question will be about legal positivism. Then we'll speak about historical school of law. It will be third question. Fourth question, sociological approach. And fifth question, integrative theories of law. So we'll discuss some main approaches to law. Maybe you know something about these approaches. And of course, you can comment something, you can ask something. If you don't understand, what will I say? So, historically, there are two main approaches to law. Maybe you know what are these approaches. Two main approaches. I think it's
natural one.
Yeah, of course, natural, yeah, legal naturalism, and second one.
Positivistic.
Legal positivism, yeah. Marina, thank you. Legal naturalism and legal positivism. So, natural law or legal naturalism, which can be thought of as the idea that power of law doesn't come from voice of authority. Yeah. In contrast, positivism says that it is the authority what makes the law. Yeah, maybe this is the main difference between natural law and positivism. But I should say that it's not the main difference between naturalism and positivism. I'll explain, I hope. So, first question about natural law, legal naturalism, or another name of legal naturalism, Jusnaturalism. So, natural law has many different schools of thoughts, but the basic principle in the end is that laws, in order to be valid, must be moral. In other words, the famous phrase, an unjust law is no law at all. Natural law can refer to the several doctrines. And I want to say about these doctrines. The first, that just laws are immanent in human nature. Yeah, maybe you heard about this understanding of legal naturalism. Immanent, that just laws are immanent in human nature. That is, they can be discovered or found, but not created by such things as a Bill of Rights. Next doctrine that can explain what is natural law, that they can emerge by the natural process of resolving conflicts as embodied by the evolutionary process of the common law. And the last doctrine which can explain what is natural law, that the meaning of law is such its content cannot be determined except by reference to moral principles. These meanings can either oppose or complement each other, although they share the common trait that they rely on inherence as opposed to design in finding just laws. And I should say that the concept of natural law was important in the development of the law. I think you can agree with me. And legal systems, I think you know this, have a function to secure justice. And grossly unjust law, do you know what is grossly or not? Can you translate grossly unjust law? Okay, maybe you can translate now this word, but I'll say about some examples and you'll understand what is this grossly unjust law. For example, I mean, white people may own black people as slaves. I think you can agree, and it's really grossly unjust laws. Then another example, women may not own property or vote. Yeah, so grossly unjust laws are not really laws at all, but a perversion of law or mere violence. And here I should say again about some example from medieval philosophers, for example, from St. Augustine or Thomas Aquinas. And as St. Augustine said or put it, lex injustia non est lex. This is in Latin, and I think you can understand the translation of this Latin sentence. And a few words about Thomas Aquinas. Thomas Aquinas' way of stating this point we can understand in such way. Positive law has as its purpose the common good of the community. Any positive law which conflicts or is consistent with either natural law or divine law is not really law at all. Hence, not only there is no moral obligation to obey it, but there is no legal obligation to obey it either. So we can speak and we can say that Augustine, Thomas Aquinas, and even Martin Luther King are supporters to these views. I mean, some approach to law with the name of legal naturalism. And then I should say about the understanding of natural law from Thomas Aquinas. It was interesting hierarchy of laws, and Thomas Aquinas distinguishes 4 kinds of law: eternal law, natural law, human law, and divine law. And he explained eternal law in some way. Eternal law governs the nature of the universe, divine law must help human beings to achieve eternal salvation. The precepts of divine law may be disclosed only through divine revelation. The natural law, attention here, governs the behavior of being possessing reason and free will. The first precept of the natural law is to do good and avoid evil. And the human law we can understand like a written law. The human law is valid only as its content conforms to the content of the natural law. And again, to paraphrase Augustine's famous remark, we can say an unjust law is really no law at all. Maybe you have some questions, please, you can ask. I hope you can understand now what is legal naturalism. Yes or no? Tell me, please.
No, we don't have questions.
Perfect. Thank you, Diana, for your feedback. It's very important for me. Okay, but I want to give another example, and you can compare some norms and ideas and say what is naturalism and what is not naturalists' ideas. To give an example, for example, anti-Semitic and racial Nuremberg laws of Nazi Germany, yeah, they were enacted by Reichstag in 1935. The two laws were the law for the protection of German blood and German honor, which forbade marriages and extramarital intercourse between Jews and Germans, and the employment of German females under 45 in Jewish households. And the Reich citizenship law, which declared that only those of German who related blood were eligible to the Reich citizens, and the remainder were classed as state subjects without citizenship rights. I think you can understand that it was anti-example, yeah, of the ideas of the legal naturalism. And those laws became a normative base for the Holocaust. I think that you know that it was a genocide during World War II, when Nazi and their collaborators systematically murdered some 6 million European Jews. Of course, we can compare with our time, but I think we shouldn't do this now. So we can go to the next slide. In here, I want to demonstrate the natural legal doctrine, or Jusnaturalism, in some short sentences. For example, if you will speak about the hardcore of Jusnaturalism, the hardcore of Jusnaturalism is the following idea, yeah, and this idea is law always contains standards principles, ideas, or other components that don't depend on external factors. What is this? How can we understand this sentence? It means that law has own content, yeah, some ideas, and some external factor cannot improve, yeah, something with this situation. It cannot change something, yeah. Then the natural law doctrines or doctrine is based on the idea of the existence of a necessary link between law and morality. This is the other main feature of the legal naturalism. If you remember, in the very beginning of our lecture, I said that the natural law can be thought of as the idea that power of law doesn't come from voice of authority. Yeah, doesn't come from voice of authority. It was the first main feature of legal naturalism, and the second main feature is the idea of the existence of a necessary link between law and morality. And third moment, the content of law depends not only on social or normative facts, but also on those ideas whose existence in law itself makes it a social system that is substantially different from other social systems. Okay, and here I should say that the idea that a norm that doesn't conform to the natural law cannot be legally valid is the defining thesis of conceptual naturalism. Then I should say something about classical idea of naturalism. And classical naturalism doesn't deny that human beings have considerable discretion in creating natural law. But such discretion is necessarily limited by moral norms. Legal norms that are promulgated by human beings are valid only if they are consistent with morality. I should say that some critics of conceptual naturalism have raised a number of objections to this view. Of course, we can speak about proponents of this idea and opponents of this idea. And first, unjust laws are all too frequently enforced against person. We saw the example with of the Holocaust. And another frequently expressed worry is that naturalism undermines the possibility of moral criticism of the law. Inasmuch as conformity with natural law is a necessary condition for legal validity, all valid law is, by definition, morally just. I think, again, that you can understand what is legal naturalism. And then I just want to show you next slide with a protective layer of Jusnaturalism. So I want to speak about proponents of legal naturalism and some ideas of legal naturalism. Now you can see some concepts of Jusnaturalism, some European tradition and Anglo-American tradition. some concepts in the sphere of overlaw, critical theory of law, morality of law, and so on. It's just protective layer of Jusnaturalism. I hope that you know what is protective layer or what is layer. Yes or no?
Yes.
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 I just use the terminology from the one famous philosopher with the name Imre Lakatos.
Yes, yes.
Imre Lakatos. Thank you, Anastasia. Thank you, Diana, and other students for your feedback. And this terminology can give us some understanding what is good in this approach and what is not good, or just from we can speak just about ideas from proponents and opponents of the legal naturalism or Jusnaturalism. So here we can see positive and negative heuristics of Jusnaturalism. In other words, we can speak about ideas from the opponents and proponents about Jusnaturalism. So, first moment, usually philosophical ideas of phenomenology and hermeneutics are used. Maybe you don't know what is hermeneutics. I can translate for you or explain that it's just interpretation in the sphere of law. Yes, of course, it's very important moments for Jusnaturalism because we can take some ideas from philosophy, for example, phenomenology or interpretation or hermeneutics, in other words, and use this idea in jurisprudence. Next moment, convincing metaphors are preferred to the rigidity of logical construction. I mean, in European tradition. It means that in this approach, legal naturalism, more popular, the ideas of legal metaphors are more popular than the logical constructions. Yes, maybe it's not so good, and that is why the proponents of this approach said that it's a very, very bad features of the legal positivism, that legal metaphor is not perfect in the jurisprudence because legal or because logical constructions are fit, yeah, to the jurisprudence. Not fit, I don't know how to say even. It's better ideas than legal metaphors. Maybe you know what is legal metaphor. Maybe you can speak, you can say about some example of legal metaphor or not.
Can you repeat?
Legal metaphor. Some example of legal metaphor.
We don't know.
Don't you know? You don't know. Okay. For example, legal metaphor can be with the name state mechanism, yeah, or mechanism of the state. It's like a legal metaphor because state is not mechanism in our understanding. Yeah, we can use just this legal metaphor and all of us can understand what is this. What is logical constructions? I think you know, because for example, it can be some laws with some logical constructions, with some norms, some parts of these norms, yeah, and so on. Then one of the key issues is the idea of justice and the possibility of this realization in the positive law. In the positive law, I think it's not so difficult for understand what is this, and it's good or not good. Then, and next moment, it's that Jusnaturalists are nearly not interested in the language problems related to analytical philosophy. Yes, this sphere of legal positivism, not the legal naturalism, maybe is not good. It's not so good for legal naturalism. This is the idea from the proponents of the Jusnaturalism. So next peak and what happened? And I want to say and show for you the ideas and definition from the sphere of legal naturalism, and the author of this definition, Gustav Radbruch. He said, legal orders cannot be recognized as valid law if they contradict to the fundamental principles of justice. So obviously that the judge who wished to apply them instead of law would form the anti-law. When the injustice of law becomes unbearable, he must retreat to justice. I think you can translate later this definition, but this definition reveals this approach and demonstrate what is legal order from the position of legal naturalism. Then another definition by Otfried Hoffe, as the highest manifestation of the strict universal rules, law is opposed to personal arbitrariness and personal violence, and therefore has to rule over people. I think the definition of Lon Fuller is very important. That is why I want to give you some comments. American jurist Lon Fuller rejects the idea that there are necessary substantive moral constraints on the content of the law. But Fuller believes that law is necessarily subject to procedural morality. And on Fuller's view, human activity is necessarily goal-oriented or purposive. And insofar, particular human activities can be understood only in terms that make reference to their purposes and ends. Thus, since lawmaking is essentially purposive activity, it can be understood only in terms that explicitly acknowledge its essential values and purposes. So you can see slide, and the definition in the sphere of legal, from the sphere of legal naturalism. Legal morality is the natural laws inherent in a particular kind of human activity, which I described as an act aimed at subordinating human behavior to the rule of law. Okay, and as you see, he said about some system of rules, system of rules, but this system of rules are not from the sphere of positive law. This system of rules must satisfy the following principles. What are the principles? The rules must be expressed in general terms. Then the rules must be publicly promulgated. The rules must be prospective in effect, must be expressed in understandable terms, and the rules must be consistent with one another. Then the rules mustn't require conduct beyond the powers of the affected parties. The rules mustn't be changed so frequently that the subject cannot rely on them. And the last principle, the rules must be administered in a manner consistent with their wording. So in such way, we can comment what is the examples of the definitions, of some definitions and understanding in the sphere of legal naturalism. If you have some questions, please ask, because we will go to the next question. And our next question, legal positivism. Don't you have any questions?
Can you repeat about what system of rules must satisfy it? You told that
the following principles. Yeah.
Okay.
Okay, perfect. And I didn't say to you, you can see this lecture later at my YouTube channel. I'll send to you some invitation and you will see this lecture. And I think your preparation for your future seminars will be just very good. You hear me? Did you understand me?
Yes.
Yes.
Perfect. So, legal positivism and ideas of legal positivism. What is this? And how can we understand what is legal positivism? Legal positivism considers that the existence and content of law depends on social facts. and not on its merits. I think it's interesting idea of legal positivism. And if you will try to reveal what is legal positivism from the level of terminology by Imbrulakatas, we'll have the ideas of hardcore of legal positivism. So the hardcore of legal positivism is the following idea. Law has no own content. That is the content that wouldn't be determined by any external for the legal system factors. Yeah, I think you can notice that it's some opposite to the legal naturalism. Then an important idea of legal positivism is the so-called separability thesis. Separability thesis, what is this? Or in the other words, thesis of delimitation. The essence of this thesis is the statement of the absence of a necessary connection between law and morality. Yeah, and again, you can see the difference between legal positivism and legal naturalism, because for legal naturalism, morality is the main feature, main idea, and for legal positivism, the situation is absolutely opposite. So separability thesis is an important element of the hardcore of legal positivism. And legal norms are different from all other rules and standards that exist in the society. This is another main idea of legal positivism. Next moment, the protective layer of legal positivism. And here you can see again some concepts of positivism, exclusive positivism, and inclusive positivism. And here we can see the ideas of neo-positivism, normativism. So these all ideas are about some variants. So, yeah, some variants of legal positivism. And of course, we should speak about positive and negative heuristic of legal positivism. What is this? These positive and negative heuristics. Firstly, legal positivism is usually oriented to the exploitation of analytical philosophy. Yeah, and here we can see that, yes, of course, this is another difference from the legal naturalism. Legal naturalism doesn't like the analytical philosophy. Then, perfection of logical constructions combined with the desire to provide an argument to all without any exceptions thesis. Yeah, this is the main idea of legal positivism. And of course, some argumentation, logical construction are very important for legal positivism. Then orientation to the analysis of the current legislation. Yes, of course. And here you can see that maybe it's not bad feature of the legal positivism. I mean, this orientation to the analysis of the current legislation. And another moment, another characteristic of legal positivism is that phenomenology, dialectics, existentialism have little or no use at all. And of course, the proponents of the legal naturalism will say, oh, it's so bad because we cannot use these ideas in the sphere of jurisprudence. So now you can see some difference, and we'll speak about some definition or definitions from some jurists and philosophers who were the proponents of the legal positivism. So the first lawyer, the English jurist John Austin, and I should say that the years of his life were from the 1790 to 1859. It's just for your
Вибачте,
orientation.
будь ласка, вибачте, що вас перебиваю, але тут тривога почалась. Що ми виходимо чи ні?
Yes, I see that's it's not good for us. Yeah, air raid emergence. Yes, I think we should say to each other a little